last session of this day. The next speaker is Andrew Saunderson, who I mentioned in the previous session with Samantha. I last spoke with Andrew in his own offices just down the road from here in London, because he's a partner at Field Fisher, one of the large legal firms in London, with a very, very significant division dealing with all aspects of construction, through appointments, contracts, right out to contentious issues. Andrew's got a fantastic range of experience on construction litigation. I think what we're going to see or hear from him is some kind of a summary of just where things are going in this period since we last spoke together. So it's great to have you, Andrew. Expertise in relation to transport sector, including road transport matters, health and safety, corporate manslaughter, coroner's inquests. He advises clients in relation to anti-bribery and corruption, fraud and regulatory compliance, as well as work in construction, directly in construction itself. So, Andrew, it's very good to have you with us. You're very welcome, and the floor is yours. We're going to do the same thing as we've done before, which is a presentation with slides. I think there's 14 pictures coming up here that Andrew will speak to, and then a 15-minute Q&A. Keep your questions rolling in. We had plenty for the last session. We've had plenty all day long, actually. I'll keep an eye on them and try and feed them into Andrew after he's given his 15-minute presentation. Andrew.
Good afternoon, everyone. Paul, thank you ever so much for that. It's much appreciated. I'm never sure whether being the last speaker of the day, especially being a lawyer, is a good thing or a bad thing. I'd like to apologise for my slight dress down, but I'm currently on holiday in Cornwall, so didn't have a suit and a shirt with me. But hopefully that won't matter for the purposes of this presentation. Good afternoon, everyone. As Paul said, my name's Andrew Sanderson. I'm a partner at Field Fisher. I head up the health and safety team here, and we have a huge amount of experience in the construction world, looking after a variety of organisations and individuals who find themselves perhaps facing challenges either in the courts or by the regulators with investigations, prosecutions, or civil claims. As Paul mentioned, I'm going to do a 15-minute presentation, which will be a very quick overview of some things that are going on, which I hope are of interest, and then some Q&A, which I think has been the main focus for today, which is great. I should say my slides will be available, so anyone who wants to have a look at them, please feel free to after the presentation. 3 areas we're going to be looking at: a review of recent case law, civil, criminal, and regulatory. The second question is who's currently carrying the can for failed design construction, and what do architects need to do and need to think about both now and in the future. So starting off with the case law, I've picked out some that are of interest for particular reasons. The first one, the Rush Bond case. There's a summary of it up on your screen now. This was a fairly recent case in the Technology and Construction Court, which I'm sure you're all familiar with. Hopefully not too familiar, but have certainly come across it in a professional capacity. Essentially, the defendants, the JS Design Partnership, sent one of their architects on site to the claimants, Rushbond PLC, to one of their properties to carry out some inspections, to carry out some observations and some work. What was alleged was that the individual that attended effectively left part of the property open. There was then a fire that occurred that caused around about £6.57 million worth of damage. And Rushbond basically said, well, that's your fault. It's one of your employees. It's your fault. We want you to be paying for this and getting this sorted out. It was based on common law duty of care. The Technology and Construction Court disagreed and said that there was no such duty of care in this case, that the defendants, JS Designs, did not owe a duty of care in this case, that it was an omission that occurred, but they couldn't be held liable for the damages that occurred, around about 6.5 million, as I said. The reason I thought it was quite interesting to include this is primarily because courts are looking at situations whereby where incidents are occurring, and then there's issues occurring, and people are alleging that, or organisations, are alleging that there is responsibility and liability on a party. They're trying to get to a situation whereby there is a little bit more clarity around this area. There has been some previous cases which I haven't included in this presentation, primarily because I don't have time, but would be happy to share those that sort of show the development. I think it's an important area for people to keep an eye on. The next case that I've identified is in Manchester Crown Court. It involves the Health and Safety Executive, which is obviously a particular area of interest and expertise for myself and my team. Bearing in mind we spend a lot of time defending organisations in relation to health and safety claims. This related to a property refurbishment by iProject Cheshire Limited. There was some works carried out, and the foundations of the property were undermined, causing a partial collapse of the building. There was an investigation undertaken by the HSE, primarily because of the seriousness of the collapse and also the potential for very serious injury, and the possibility of a death occurring, although it didn't occur, but that's where the HSE started from. Effectively, what the HSE said was that there was a failure in terms of producing proper plans, proper documents, proper policy documents, and as such, iProject pleaded guilty to the charges and were fined £31,000 in order to pay costs in the region of about £13,000. The reason I include this is because there's always a lot of focus in terms of the civil cases and the regulatory cases, but in terms of the health and safety and the criminal cases, sometimes these go under the radar a little bit. I'm sure you're all aware, and you don't need me to tell this, but having a prosecution like this against a practice, against an individual, has reputational impact beyond that. Whereby there was the fine, and there was some commentary from the HSE that this situation could have been avoided fairly easily in terms of just making sure policies and procedures were put in place. From a regulatory aspect, I've picked out this case going back to, it was over a 2-month period, August, September 2020. The Thompson case before the Architects Registration Board. It involved a situation whereby there was an allegation that the properties involved, a number of flats, did not comply with the building regulation relating to fire safety, which is obviously of particular interest to this presentations today. There was investigations carried out, statements taken, and Thompson was found guilty of unacceptable professional conduct. And part of the reasoning for that was related to that it was suggested that it was not appropriate to rely on the word of contractors when giving assurances or providing information. A professional in that position cannot simply say, I've spoken to contractor X, they've assured me we've done A, B, and C. That's not that was considered not appropriate. And I should say that with regards to that, running that type of argument, that is getting less and less plausible, especially with regards to regulators such as the HSE. The HSE will often say it is not good enough for you to say, as a professional, that I've relied on what somebody has told me. Now, there are obviously exceptions to that. There are situations when you can rely, as long as you've done your due diligence and as long as you've looked behind that. But simply saying I relied on what X said to me is not appropriate. The second regulatory case that I've put up here, the Rothine case, it was in relation to an alleged serious incompetent design that had been provided and produced. The PCC found that in the circumstances there had been a number of severe failings, and also there was the suggestion that in terms of engaging in an appropriate way with the investigation, this had not happened. Nobody ever wants to be subject to an investigation by their regulatory body or any other regulatory body for that matter. It is not a particularly nice process. That is why people get me and their insurers involved in those types of situations. But what I would say is burying your head in the sand when investigations start doesn't help the situation. In fact, can aggravate the situation. And there's a lot of work that could be done to mitigate situations. The individual in this case was eventually erased in the register. So, going briefly on to who's carrying the can for design construction. It's a big question, and there are a lot of variables, and I appreciate that's a typical lawyer's answer. There is one case, Shabby Foods Limited, which is interesting in terms of sort of setting out, I suppose, what would be a fairly typical scenario. The defendant in that case was instructed to refurb part of a commercial factory. They were a practice of architects. They went away, drew up various plans, various briefings, various policies, various procedures to go through this process. But a while later, there were a number of failings as a result of the refurbishment, so physical failings. The court decided that the architects in that case were liable for those failings that had occurred due to a number of negligent acts that had taken place. So why is this case important, and why should it be borne in mind? There's mainly 5 points that come out of it, which I've summarised in the slide that's hopefully with you now, in terms of making sure that you're fulfilling statutory requirements. Looking at the other people involved within the contract itself. Are these sophisticated contractors? Does everyone who's involved in the project, do they know what they are supposed to be doing? Do they have the relevant competencies? Looking at risk assessments and not making any assumptions. That's often something that we come across where, as a result of risk assessments, assumptions are made, which is not a good starting point. In terms of if things change as projects develop, which they do, then are these being noted, and are these being documented, and are they being reviewed in an appropriate manner? In terms of another example, SCC generation, which involved the collapse of a tunnel structure that occurred. The important bit that the court decided when holding the defendants liable in this matter, even though they complied with their duty to use reasonable skill and care in the design, the court said because the defect was in the implementation of the design, which had to meet the fitness for purpose obligation. And that was the issue that they raised there. The courts are prepared to look at in detail, and indeed in some detail, what has gone on previously, what has happened in terms of the design process, what has led to that. So courts will, excuse the pun, will sort of dig through the paperwork, will dig through the history of a contractual relationship. In terms of this matter, the Eon case, which goes back a little way, I appreciate that, which related to foundation failures of 2 offshore wind farms. It basically stated that the courts were looking at the contractual relationships again. Where did liability rest? Who was liable for which aspects of which project? The important thing from my point of view, and I always say this as a defence lawyer, is that it highlighted the importance of documentation that sat behind the contract, including, I think in this case, technical schedules. And the reason for that is that, lawyers can have a look at the contracts, courts can have a look at the contracts, but often it will be said, well, what lay behind that? What was behind those? I mentioned previously, what the legislative design liabilities, what are the standards that we are looking at here. The first one set out there in bullet point 1 is in terms of using reasonable skill and care, looking at what is required for a particular job, what is required for a particular project, and in terms of reasonable skill and care, what is required. And then under the Defective Premises Act 1972, in terms of looking at fitness for purpose, under the Sales of Good Act 1979, looking at fitness for purpose and taking that into consideration with regards to a particular project. And that is something, again, going back to one of the cases I mentioned earlier, SEC Generation, courts looking at, is the project fit for purpose, and what is the meaning of, is it fit for purpose, and looking behind the contract, and also, as I said previously, looking at what documentation, what discussions have been had, not just necessarily looking at the contract itself as appears before them. So, what do architects need to think about? I've set out some bullet points there, primarily, obviously, looking at the cases that I've discussed, and also the legislation that is being provided for. I think from a practical point of view, what I would be saying to clients is, what's in the contract, what's being documented, where does liability rest? What checks and balances have you put in place to make sure that you are covered and that you are looking after yourself and your practice? That's really important. So look, from the legislative point of view, there are things that you need to be doing. That goes without saying, but it's having I suppose I call it a shield, really, for clients, having that shield in place, and that shield is made up of a number of parts. It's also sort of working with your insurers as well. I think the session before me was in relation to insurance. I caught the end of it, and it's important knowing what policies and what is covered by those. That they're in place as well, and working with other professionals such as myself who may be able to assist with regards to helping you put things in place. I appreciate that's a very, very quick skip through in terms of some of the case law. You should have the slides afterwards, which hopefully you'll be able to share with you. But more than happy to take any questions if anybody's got any they'd like to raise.
Okay, well, Andrew, that was a canter through a very wide range of issues for which we thank you. We've got 5 minutes left, but yours is the last session before we go into a panel discussion, so I'm taking Chairman's liberty to just extend a little bit because there was so much in there, and you did start 5 minutes late as well, which was our fault, not yours. So we've been taking questions all day long coming in on the screen, and I want to turn to those rather than my own straight away because there's rich stuff here again. So Liam Ross asks, and I'll just ask you, can you keep the answers very concise because we can get more questions in. Liam Ross asks, question for Andrew, does Martlet versus Mullally tell us anything about how much product certification can be relied on as a means to demonstrate fire safety? And in asking you to answer that, it has been mentioned earlier today. It is a case I know a bit about, but perhaps you could just outline briefly what the case is about as well, and then answer the question, which is how much product certification can be relied on as a means to demonstrate fire safety. That's the old BBA, I expect.
Yeah. So apologies. I haven't got that. I haven't got that case in front of me, and probably should have done as it's likely to come up in is obviously come up as a question. But going back to the certification process, it is something that is becoming more and more important, and looking at the regulator's point of view, which is where I start, because that's the person who is going to potentially look at a particular issue, or a court looking at a particular issue. They are becoming more and more, they are concerned in terms of the certification process, what process has gone through, how the parties have dealt with that, how the parties are complying or trying to comply with that. I would hope it's the former as opposed to the latter.
Right. Well, I think that it goes back to a session much earlier today in which we were talking. Sorry, we've lost you. We've lost your microphone. I think you're muted.
No, still here.
Okay, right. We had a point made earlier today on that one, but the key is when an architect or other person is specifying and the product has to perform against certain criteria in terms of fire, can they rely on the routine certification they get, for example, the BBA certificate, or should they be getting independent testing of products? I mean, that's the whole territory. It might be a bit difficult for you to answer that one as you didn't know the case, but that's the area of concern, I think.
Yeah, I think the question goes to what would be reasonable in the circumstances. So there has to be a degree of trust in terms of the certification process, and there has to be a reliance upon that. And then in terms of going away and undertaking independent testing, I think in a lot of circumstances that would be unwieldy, and it would be extremely costly, and possibly not necessarily practicable for that to be done on a case-by-case basis. So relying on the certification is the starting point. If there are any concerns or any issues raised, then obviously we would need to be looking at independent testing.
Yeah. I think it was Chris Miles and John Finn O'Neill from the Fire Protection Association who raised all this in their earlier talk. But I think what this goes to the heart at is, okay, certification, but what certification, whose certificate, what can we rely on? But here's another one.
Sorry, but I was just going to say, I think that goes back to my point of, how doing your due diligence that I mentioned in my presentation, who's providing the information to you, how do you back up that information? So doing your due diligence is absolutely key. Okay.
Now, a host of questions have come in about site inspection. So I'm going to gather those all together in a question which I'll try and phrase, which picks up everything there. If you split an architect's work, I know I keep mentioning architects, I'm talking about all who specify when I say this, but let's stay with architects at the moment. If you split their risks into two broad camps, I think you could say we're worried, I've been an architect for 40 years, we're worried about cost overrun, delays, claims from the contractor, extensions of time, all that stuff. Building finished, all was good, everybody liked it, but there's a claim from the contractor. That's one territory. We're focused now here on a completely different one, which is design and or specification errors. It's gone wrong, and we've got deep troubles in that territory. And I want to just focus there. The questions that are coming in are, what about inspection duties on site? Now, when I started my career, we'd go into the traditional RBA appointment document, and it said the architect will or shall visit the site periodically to generally inspect the works to ensure that they are generally in accordance with the contract documentation. Periodically visit the site. We chose when to go. Inspect the works to ensure generally, not specifically generally, that they're in accordance with the contract documentation. Now I can tell you straight, I'd know a builder and I'd know that we had that builder on 4 or 5 jobs. They're jolly good, they know what they're doing. This could be big job or small job, and we go less often. We turn up on a site, new builder, very uncertain about that builder. I'm going to make sure we're down there, or somebody from my office is down there, twice as often, twice as early, because we're nervous. So there's one area of trouble. A second area of trouble and is what comes before, which is the issue of a responsibility for checking drawings by others. And this is very difficult. The architect has done their scheme. They did the employer's requirements. It's gone out to tender. It's a design build contract, and they're novated. But here we have, for example, the cladding, and it's gone off to a building cladding subcontract firm with design responsibility. They are now going to carry that design forward. And the architect's next involvement with it is when they're getting the drawings in from the cladding subcontractor upon which to comment. And how do they limit their liabilities there? Or should they triple up their efforts? Or both?
That's two really interesting areas. Going back to the first bit, we sort of mentioned periodically and generally. I don't think they particularly help anyone. And you're absolutely right that you get a feeling for a particular project or whoever's involved in that project, and you may go to site, once, twice, 3 times, whatever it happens to be, but you've got a feeling for that. In terms of architects, checking the drawings of others, so they are obviously checking those drawings from their position as the architect involved in the project. And those drawings and specifications may come in from a party perhaps where they've got a different level of expertise in a particular, whether that's on cladding or whatever it happens to be. And I think in order to, I think there's a twofold answer here. One, if the architects are commenting on those drawings, they need to be doing so on the basis that they feel that they are competent to be providing comments on those drawings, and it's always a competency issue. And saying and for a profession to say, well, actually, that's outside of my area of expertise, or I need somebody else to give me a view on that. That's not a bad thing. That's absolutely, we as lawyers, if we're asked to advise on a particular area that's outside our area of expertise, then we have to say that. I think also in terms of limiting liability, I think there are ways of doing that. There are caveats that can be provided in terms of the notifications or in terms of comments that are provided. But one thing I would raise, and this isn't necessarily for me, this is probably more for the people who have expertise in terms of insurance policies, is that should an individual be commenting on a particular set of drawings, is that covered within the policies that the insurance policies that are put in place? And that's a question mark that I often raise. And the reason I raise that is... Sorry, go on, Paul.
Let's drill into that one for a second, because here we are. The architect's been novated. The building contract is rolling fast. There's penalty clauses right, left and centre for delays. And I'm not talking about the contractor to the client. I'm talking about the team that have been novated to the contractor. In come rolling the drawings. There's been major changes. And those drawings come landing upon the architect and the structural engineers and the mechanical service engineers, everybody else who's involved. And we have to check them. And we're expected to check them and comment on them to ensure that they're coordinated, to make sure that they comply with the employer's requirements, etc., etc. But there's penalties coming upon us if we're late with those drawings. Now, routinely, most architects have got a stamp, which is A, B, and C, and they'll have a stamp saying no further comment. They don't say these drawings are great. They say no further comment. But by goodness, there's some trouble if there's something wrong with those drawings. How do they deal with that? Because you say, well, they might need to turn and get other expertise. You can be in the deepest trouble before you blink, because the drawings arrived with you late, and they arrived with you late because you were late getting them out to in the first place to the subcontractor, because the program was too tight from the beginning.
Mm-hmm. Look, I totally understand that. I totally understand that position. There's obviously a commercial, there is a commercial pressure in that scenario, and there's a penalty pressure as well. And I understand that. And what I was going to say was that we dealt with a scenario whereby architects were put in a very similar situation. They were put under a huge amount of pressure to comment on drawings, or penalty clauses would have been imposed. And in that scenario, they rushed through that process, and there were issues further down the line. Now, it was a civil issue. There weren't criminal sanctions. But I would say that you need, if you need that time to look at those drawings and to make sure that you are fulfilling your role, your professional role, then that's what you have to do. And I totally understand people would say, but we're going to get penalties. There are going to be penalties imposed on us. I also understand that as well. But if you look at the worst case scenario, if something happens and you're in court and I'm defending you, it is not a defence to say we were worried about the penalties.
I've got it, Andrew, and that is a sober moment in today. That's rock and hard place stuff, and I'm not going to undermine anything you said or belittle it. You said, if you're not sure, you've got to take the time, and I get it. And that's a message for all our delegates out there. Don't be bamboozled into approving stuff that you shouldn't be approving, particularly if it's to do with safety. You will live to regret it, or you could certainly live to regret it. Now, one last thing here, before we go on to the next session. A dear friend of mine frequently says, responsibility without authority. You can't have responsibility without authority. The whole point about design build, and there are so many good design build companies out there. I've said that several times today. But the architect's authority is diminished when they end up novated and working for the contractor. And if a contractor says, we wish you to come to this site 6 times during the building program, which is 2 years, 6 times, you're no longer able to go when you wish or where you wish. And I think it's very important. I used to say to people in the office, if you've been asked to go, and we're not generally responsible for inspecting, we're just being asked on occasions, then you should really and I used to say this, you should really ask to be blindfolded at the site office and taken under blindfold to the point they want you to look at that, then get blindfolded and go back, so that you can't be responsible for anything else. Now, of course, that's I wouldn't expect that to be literally carried out, but it's a critically important thing. we have benchmarking. You know, do you go and say, well, look, if you do it to this standard, it'll be generally okay through the building, that's fine. So that's one type of inspection. The other is to go and see that the work has been done properly. Two completely different types of checking. Perhaps a last word on that, and then we'll have to wrap up.
Yeah, I mean, it's again a very difficult situation. You know, if you haven't got that authority, how can you make sure what is being done is being done? I think the way that we look at it is you've got certain professional obligations, and you need to, if you're concerned about something within a process, you need to raise those concerns. And those concerns need to be documented. I think that's absolutely key.
Okay, so that's the point at which I'm going to thank you. That's Andrew Saunderson, partner at Field Fisher, saying to you all, and it's really critically important, don't be pushed into passing stuff that you're not happy with. If you're unhappy, you know, pull the emergency cord. We need to bring everybody's attention to the issue. Don't get swept along. That's the general point that you're making, I think, isn't it? And you have to do that because you're, as professionals, you are the people that know. You understand construction as designers, architects, engineers. You know, and you must call it when you need to, because people who use those buildings will be relying on you. Andrew, there's one last point. It's not a question, it's just a thing for you to think about. Controversial, perhaps, says Michael Lucurelli. Controversial, perhaps, but is it an overstatement to say that if you have PII, you effectively have a target on your back? There's one to leave us with. Okay, thank you very much. We're going to go into our last session. I look forward to seeing you again soon, Andrew.
Thank you, Paul.
Bye.
Much appreciated.